Welcome to the virtual rebroadcast of PubCA's 2024 Government Contracts Annual Review. During this week, we are presenting 14 panel discussions featuring more than 70 expert practitioners, as well as 2 in-depth conversations with key government officials. PubCA publishes news and insights for the government contracts community, such as PubCA Protests and Claims, PubCA Cybersecurity and Data Privacy, and PubCA Compliance and Enforcement. In addition to our annual review, we also host webinars, podcasts, and in-person networking meetings during the year. If you'd like to learn more about PubCA, visit us online at pubcagroup.com. All of this week's presentations were recorded live at our in-person conference in February at the Ronald Reagan International Trade Center. You can join any or all of these sessions during the week using the same link and password you used today. All attendees will be in listen-only mode. Your video will remain disabled through the entire session. Many of our panelists are joining us today to answer questions about their presentations. Enter your question into the Q&A box at the bottom of your screen, and the panel will address as many as possible during the webinar. If time allows, we'll open up a live Q&A session after the video presentation. Our briefing book, which includes all of this week's slide presentations and other materials, are available for download from the PubCA website. We are applying for continuing legal education CLE approval in Virginia, California, Texas, Florida, Colorado, and Kansas. While we cannot guarantee approval, we expect acceptance within the next few weeks. We will notify all attendees when those approvals have been received. If you received CLEs for our in-person event, you can apply for additional CLEs for panels that you may have missed. And finally, if you are interested in obtaining CLE, please look for our poll question during the presentation. The state boards require us to verify your participation during the event. The poll is a simple yes/no question. We will keep track of all responses to verify that you viewed the panel. If you do not wish to obtain CLE credit, you can disregard the poll. This conference would not have been possible without the strong support of our event sponsors, all of whom are listed on the next few slides. Our sponsors also provided speakers for our event and other valuable input. We encourage you to review the strengths and capabilities of these firms and to reach out to them directly with any questions you may have. And now we present our next panel, Investigations, Disclosures, Suspension, and Debarment.
This is Investigation, Suspension, and Debarment. We are delighted to be here with you. We're delighted to be here in person with you. And PubCA, you've done a fantastic job. We're very grateful to be here. So let's tell you very briefly who we are, to the extent you don't know who we are, and what we're here to do and what you can expect. All right, first, what you can expect. We're going to have a scenario-driven event today. We want you to see the moving parts of a suspension debarment case and an investigation matter and what we're all thinking about in a way to keep things lively. We also recognize that that doesn't get you all CLE. So we've done a lot of substance at the front. Our slides in the book, we're not going to cover all the slides. We're going to move through that pretty quickly. The real meat is going to be in the scenario itself. So bear with us. I think you'll find this pretty enjoyable. Let us go through who we've got here. We've got Todd Canny, partner and co-chair, Government Contracts Practice at Baker Hostetler. We've got David Hickey, partner and chair, Government Contracts Practice at Kelly Dry. We've got me, partner and co-chair, Government Contracts Practice, Jenner Block. And Mike Wagner, partner at Covington. Okay, that's who we are now. Let's dive right into substance. Here's what you're going to see today. And starting the overview of suspension debarment is going to be Todd.
Hello. Thank you, David. Just going to, for a moment or two, just cover the latest ISDC report, which ended. So the first issue with the ISDC reports is they're reporting on, by the time they're issued, the data is pretty outdated. So we don't want to make a really big deal about it. Thankfully, David covers more active suspension debarment activity, and so we're going to go to that. But a lot of work goes into the ISDC reports. Dave and I used to contribute to them when we were with the Air Force. And I can tell you there are some positive takeaways. One, activity overall is down, which is, I guess, a good thing. when you look at it like pre-COVID. It is still a healthy and often used tool in the government's overall arsenal. You're still seeing, 2,000 or so, over 2,000, probably 2,500 suspension debarments, proposed debarments a year. A lot of those are double counted. But what we're also seeing from this is pre-exclusionary engagement they're tracking. So that's when, as often many of you know, contractors will go in proactively and voluntarily and bring an actual matter that might be a cause for debarment or cause for present responsibility concerns to the agency that they think is the lead. And so we're seeing more of that. At least they're tracking more of that. Frankly, it's been going on for 10 years, but they're actually tracking it. The other thing they're tracking is an increase in administrative agreements. They had a huge uptick, over 170 of them in 21. Turns out, I looked at the data, 132 of those were with HUD. And it seemed to be an anomaly because it went down to 11 in 22. So, they still have quite a few overall, 75. The key active agencies still remain among DOD, Navy, Army, DLA, DHS, EPA, Department of Labor, and then Air Force. So those are the top 6 or 7. There's a couple things, that I noted, in just the report doesn't track things that I think are even perhaps more important, which is that these agencies often get sued. Sometimes we bring the litigation. The report doesn't track that at all and the outcome of that litigation. I think that's a good barometer for if the agencies are, working in accordance with the FAR and due process. I think that's about it, David. I think I'll turn things over to you to give us the latest 2023 data.
Sure thing. And you see what I talked about earlier. We're just going to try and move through this pretty quickly. So Todd noted the ISDC report has been delayed in recent years. It's required by statute to be annual. It just doesn't say when those annual reports need to be issued. And so I started in fiscal 2016 tracking the end-of-year system for award management data for a limited subset of agencies. And I'm sure there was a reason why I started tracking mostly DOD, GSA, EPA, whatever, in 2016. I honestly don't remember what that rationale was, but I've tracked all of those same agencies now for a number of years, come year end. And what I've seen is a dramatic decline in suspension and debarment numbers. Todd noted HUD is active, Customs and Immigration, also active, but the core government contracts agencies have dramatically fallen in their suspension debarment activity. And we need to know that that's happening, and we need to recognize, and I think the ISDC report is a good bridge to recognizing publicly now, finally, what's driving it. Proactive engagement is the name of the game. You reach out in advance. You don't let the government suspend. You don't let the government propose debarment. You engage early. And that's reflected in a lot of what we're seeing now. Numbers have fallen, activity has fallen, but that doesn't mean that we can rest on our heels, that we can consider suspension debarment as any less of an existential threat than it's been. And I think it's the proposed rule aligning the FAR and the non-procurement common rule that also echoes some of that shift towards proactive engagement as well. So with that, Mike, do you want to talk a bit about the proposed rule?
Yeah, sure. Thanks, David. David mentioned aligning the FAR with the common rule. Of course, the FAR debarment regulations are set forth at FAR subpart 9.4. The common rule, the debarment regulations that govern grants, cooperative agreements, and other non-procurement transactions are set forth at 2 CFR Part 180. And there have been for some time now some interesting distinctions between the FAR and the common rule. And just a few weeks ago, we saw a proposed rule issued. This is the first substantive change to debarment regulations in quite some time. And the basic purpose of the proposed rule was twofold. One, to better align, not completely align, but better align the FAR rule with the non-procurement common rule. And two, to better align the FAR rule with the actual practice of suspension and debarment as it's practiced here in 2024. And so maybe I'll just flag a couple changes that are, I think, interesting and worthy of attention for folks who practice in this area. One is we have a definition of an administrative agreement for the first time. That is, I think, a recognition of the growing adoption of the use of administrative agreements by executive branch agencies either to resolve or in lieu of a suspension or debarment. As Todd mentioned, we've seen some anomalous data from year to year sometimes. I don't know if HUD is going to do 132 administrative agreements every year, but certainly we are seeing now across the executive branch agencies utilizing administrative agreements, and I think that's a good thing. That's my own editorial view, but I think it's inures to the benefit of the contractor and the government. Two, we see similarly a recognition and use of pre-notice letters. David mentioned this. I think David is correct. I agree that this is largely what is driving the decline in recent years in total numbers of suspension debarments. I think contractors are getting wise. You realize you can reach out, you confront the issue, you can give the government some comfort, make sure that we are protecting the taxpayer, but also avoiding that ultimate penalty. And maybe I'll just touch on one more so we can keep moving. We have some new mitigating and aggravating factors that are now have been proposed to be incorporated into the FAR regulation. So in FAR subpart 9.4, historically there in mitigating and aggravating factors, and that is just to better align with the factors that we see set forth in the non-procurement common rule 2 CFR part 180. So the idea, again, sort of stepping back, we want to align the FAR to the way in which suspension debarment is actually practiced these days, administrative agreements, pre-notice engagement. And we also want to try to cut down on what were perceived to be, inconsistencies between the leave it there for now, so we can keep moving.
Great. So this is the time where we're going to transition into the scenario. As you've seen, I had some trouble with the clicker and keeping the slides forward, so I'm going to just verbally signal to the folks running the show that we're going to move forward and just want to make sure we get right the hypothetical. Okay. Would you like to introduce?
I would.
Thank you.
We thought that going through a hypothetical would be a good way to bring to life a lot of the regulatory and practical considerations and confronting an issue that comes to folks in the compliance area that gives rise to suspension of debarment issues or otherwise. So this hypothetical, the contractor in this case is a wholly owned small business. They're in the staffing business, and they recently graduated from the 8A program. They have several contracts, staff augmentation contracts across the Department of Defense and its agencies. And one particular contract that is important to this particular contractor is up for renewal. So they're eager to secure that contract. There was some level of merger acquisition activity that there are new capture management and new business development executives that are part of this contractor, but there are also legacy staff. And the atmospherics within the actual contractor building is that legacy staff is less worried about the actual competition for this renewal, commenting in the hallway and around the coffee cooler that the competition is not really an issue. And more specifically, an individual, the legacy head of business development, actually talked to a mid-level manager of the company and stated that several competitors had decided we would all win some work and agreed which to win among themselves by managing pricing, which obviously is going to raise issues of compliance that give rise to a mandatory disclosure or suspension of debarment issues, and we're going to discuss the phases of consideration.
It's a bid rigging collusion scenario, right?
Right.
Right, okay.
So
Make sure we
whenever
didn't change it before we got out.
Same scenario. Whenever these sorts of things come up, for those of you who watch Seinfeld, I keep thinking George Costanza asking, "Is that wrong?" I got to plead ignorance on that. Is that wrong? It's wrong. Just in case you're wondering. All right. So this is where we're going to rotate through and each ask the others some questions. So let's figure out. We've got phase one. You need to have an internal investigation. But considering the type of contractor we're dealing with, is this an internal resources-driven investigation, or is this an external resource? And Mike, if you want to sort of talk through who investigates and how you make that choice, that'd be helpful.
Sure, yeah. Of course, the question of who investigates is an important question, and it's one that's going to be driven by the facts and circumstances of each case. Under the facts that David has laid out here, I think there's a couple salient points that ought to be considered. And I don't know that there's necessarily a right or wrong case, but I do think there's some points that ought to be considered. One is, and we can see at the bottom of the screen here, if we are assuming that this is a small, closely held company where we've got a 100% owner who may have been aware of the alleged conduct, that is going to counsel against handling this investigation internally. If someone who is potentially a subject or the investigation, or would be a fact witness even in the investigation, would have authority over, by virtue of his or her role at the company, the investigators, that could present a conflict that could hinder a full and thorough investigation, or at least cut against the incentives to conducting that kind of investigation. So in this case, when you have that sort of fact, you might want to lean more towards outside counsel. On the other hand, though, we know, and we all work with clients who have very sophisticated and well-staffed internal functions, and in many cases, if you didn't have that sort of fact, your internal folks may be very well equipped to be able to jump on this quickly, run to ground, especially given that we have a bid coming up here, run to ground as quickly as we can. This time will be of the essence, maybe more efficient that way. And if you need help sort of supplementing, force augmentation to make sure that you're going to get it done, maybe you want someone to come in and give you a sanity check, then you can also use outside counsel in that regard as well. So there's a couple different ways to structure it, but I think for this scenario, the 100% owner piece certainly is very relevant.
Yeah, that does complicate things a bit. So we've done the who investigates. Now on the how. We've heard some things that some investigations are document intensive. We've heard some investigations you really just need to interview people. What do your first few investigative steps look like, Todd, here?
I think in this situation, more than likely, there aren't going to be a lot of communications on the topic, at least if they're good criminals. So my guess is it's probably going to be a heavy interview, based situation. And I would like to speak to, the former the legacy employee that brought the issue up, see if you can gather as much in terms of the who, what, when, how, and then do some, some searches within their systems. But ultimately, I do have a case that comes to mind, but very rarely do the folks put it in writing and make it so obvious for the investigators. So I would expect that they haven't done so here. But the way he's laid it out is that we're not too worried. We've basically allocated the CLINs, or we've allocated the work. Sounds like the agreement's pretty far advanced, and so I'm guessing there's some memorialization of that somewhere. And so I would be looking at documents too, and trying to support that with interviews.
For those of you in the audience who have tried to bring your own devices to work, cell phone data, to support an investigation, you know the pain of this aspect of the investigation. That's a complicating factor too, but that goes beyond the scope of this panel. Hey, David, we've all heard about the procurement collusion strike force. We've got a market allocation issue here. How does this being a hot button topic in our area impact the advice you're giving about how to investigate and what to do next?
I think that clearly if the government has come online and stated to the contracting community that this is a priority of enforcement, and that priority from a subject matter of collusion, fraudulent activity, and the antitrust division is the lead for that particular task force, that strike force, that it does raise the risk profile. Right now, at this point in the hypothetical, it's an internal issue, but you also have to look and see which actors in the government are potentially going to be involved here. With, I think the latest numbers were 30,000 across various agencies, IGs, U.S. attorneys are involved and tasked and resourced with weeding out this particular type of wrongdoing. So it just raises the risk profile, raises the intensity of the investigation, versus a very relatively minor infraction that might not require government intervention. They've already stated their enforcement priorities, so you need to pay attention.
Got it. Thank you very much. All right, so we're going to click the slides forward to phase 2 and whether to disclose. Mike, do you want to walk us through this one?
Sure. Yeah, so we're off and running with our investigation, and very quickly, in my experience, particularly if you've got serious allegations, we don't know if they've been substantiated, but these are serious allegations, very quickly you're going to at least start thinking about the question of do we need to disclose, or will we need to disclose, or at what point might we disclose? Obviously, I think folks in the room are familiar with FAR 52-203-13. That's the mandatory disclosure rule, which requires timely disclosure of credible evidence of covered violations. And if we go to the next slide, we can see here a couple considerations. And David, maybe you can walk us through, when you're thinking about this question, it's a big question, whether or not to go in and show your hand to the government. What sort of considerations might counsel both for and against making that kind of disclosure?
And the disclosure rule is just so full of undefined terms. We've talked about this a bunch, right? So there's no set meaning of timely other than before the government gets there otherwise, right? But we have the ability to investigate. So ultimately, it's just an analysis of when do you need to bring things forward, how much do you want to tell, and what moving parts are in play. Do you have a bid coming up? Do you think a competitor or a competitor-mate, a fellow co-conspirator might get there first and get credit you might otherwise want? And so we're just evaluating all these various components to try and figure out whether an initial placeholder makes sense. Hey, we're looking into this, we're going to update you later so you get some credit for going first. Not DOJ-style credit, that's different, but keeping an SDO on the sideline credit. Or whether we need to investigate more, figure out how we're positioned, figure out how deep this misconduct, this collusion might go, and know how many people within your organization you may need to excise before you disclose. So those are the questions kicking around in my mind, and every single case has been different about whether you make the disclosure or not. Does that do justice to your question?
Yeah, no, that's good, and I think it's impossible to answer it objectively because, as you say, it's always going to be fact-specific. One of the trickiest, I think, parts of that disclosure determination is this question of credible evidence that you alluded to. David Hickey, bring you in here. How do contractors think about credible evidence? It's not a defined term. You can go back through the regulatory history of the rule and try to, divine some sort of meaning from that discussion. But as a practical matter, how should we be thinking about that, and how do you counsel your clients in those types of situations?
I think it's relative, just like timeliness is not defined, so there's a judgment call to be made. I think from a practical standpoint, if you look, FAR Part 3 uses credible evidence, you look at FAR Part 9 and the suspension and debarment uses adequate evidence. That is clearly not a very high threshold, so you don't need to put on a sort of white-collar defense, go into the court hat and say, is it going to be something that's going to be criminal, that you have to meet all of the various elements of any particular charge, in this case, any of the antitrust statutes were violated. I think and on the other hand, you also don't just get a hotline call that somebody, we heard this in the hallway, is that credible evidence? Clearly not. So as you go through the investigation and as you look at the nature and the elements of any particular offense that you're investigating, you start filling in the facts that you've gathered and to see whether or not there's a tipping point in filling out that particular violation to say, yeah, this is credible evidence. We might not even be done with the investigation, but we have to seriously consider whether to make a mandatory disclosure and also whether to engage in that proactive engagement that we've been discussing.
Yeah. And I think that all makes sense, and I also think that as a practical matter, if you do make a disclosure, I think what we've seen become sort of the standard protocol is you couch that disclosure as it's an abundance of caution. I don't think there's ever been credible evidence of a covered violation in a disclosure.
Oh, absolutely there has, but when you're disclosing conduct by somebody else.
Yeah, right, sure, yeah. Then if their conduct is credible evidence, yeah. Okay, so that's the credible evidence piece. The timeliness piece is the other challenge. Todd, we've talked about how that's not a defined term, but of course you want to get in there before there's some question about you dragging your feet, especially given that there's a potential debarment remedy if you fail to timely disclose credible evidence. So how do you sort of balance that timely piece with the need to actually conduct the investigation and get your arms around the facts?
Yeah, I think that's the key driver in every case is when to disclose once you realize you've got something here. The factors that would make this a little more pressing in my mind, or whoever goes to DOJ first is going to get a marker in this case. So I mean, that's the first thing. And once someone goes in, they're going to start tailoring the story and the narrative, for their best interest. So I would think it's one where we could speak to this, the legacy manager, very quickly and learn how credible it is, what he knows, and try to get to the bottom of it very quickly. And then just even a preliminary disclosure to the Department of Justice and the SDO's office, I think would be my, what I would be thinking about, and pretty quickly, because once you make that, you have at least shown good faith, interest in remediating this. And then I think you can take your time from that point on, but I would be thinking quickly because third parties are involved and in turn aware of it.
Right. So the risk of getting
the risk is huge. If it's an internal matter, I think you have more time to get your ducks in a row and see if it really is something, right? But it's as David says, every case is unique, right? I hate to give that, but it truly is, and you got to just consider the risks and you got to be pragmatic.
Can I ask a quick follow-up question about something you said, Todd? You said you were considering a disclosure or would consider a disclosure to justice. Is that through the IG, knowing that they're an ultimate recipient? Or are you making a proactive outreach to justice in this case?
Yeah, I mean, I think, going to the middleman doesn't really make sense, right? I always want to go to the person that actually holds the weapon. So the borrowing office and DOJ directly. I think of course, we need to satisfy the letter of the law and go to the CEO and the IG, but who worries me most, the borrowing official first, then DOJ.
That's fair.
I will say that, as a practical matter, I mean, there is coordination between IGs and especially certain agency IGs, DOD, of course, and counterparts and colleagues over at the Department of Justice. So whether or not you reach out to DOJ, you should anticipate, if you're thinking about making a disclosure to an IG, especially if it's DOD, you should anticipate that it's going to find its way to DOJ.
Yeah, and the other thing is you give a carpenter a hammer, everything's a nail, right? So truthfully, with the focus on procurement fraud in the collusion context, every case looks like one of those if that's what you're doing every day. So I think there's a benefit of bringing things directly to the decision makers on who's going to take the potential case and telling them your view of it before someone else starts presenting a view that could be completely inconsistent with what your client is saying.
Recognizing that we built in 10 minutes of flex, thinking we would not be able to keep ourselves to the limited time that we allocated, and we're running exactly on time. Can I ask something unscripted before we move along?
David,
you rascal.
Would it help the audience to hear what the distribution mechanism is when an IG, DOD IG, gets a disclosure? Would that be helpful, just to illustrate what you're saying? Todd, do you remember it? You want me to do it?
I'm happy to have you do it, yeah.
All right, so this may have changed. I've been out of the government for 10 years, right? But this is what we used to see. The disclosure goes into the central point of contact. The central point of contact in the IG's office blasts it out broadly. Suspension Debarment Office gets it. DCMA gets it. DCAA gets it. Investigative agencies get it. There's a point of contact for DOJ Civil, and there's a point of contact for DOJ Criminal that also get it. They may have added or subtracted some stakeholders, and I'm sure it's no longer an email blast. But I think that's what Mike means. Yeah. And that was the nature of the question. Do you rely on that, Todd, or do you do a special outreach?
I find that, and you bring me back to the days, but I find that they're getting so many of those now that it's almost as if I'm going to look at that when somebody tells me to look at it. For the most part, I think, it does get that broad blast, but I think people will say, when I need to look at it, somebody will tell me. And so I wouldn't rely upon that. And I also think there's an opportunity to shape how it's received.
Okay. Can I just say one interesting point on this, I think, is the question of what qualifies you for DOJ disclosure credit. And we've seen situations where DOJ will take the position that if you disclose to the IG and they consider it a mandatory disclosure, even if and there's actually a DOD instruction on this that requires that disclosure then to be delivered to DOJ, right? Even if it's going to go to DOJ, DOJ would say, well, you didn't disclose it to us, you disclosed it to the IG, and that disclosure is mandatory, so you're not going to, you may not get a voluntary disclosure credit in DOJ's eyes, even if in the course of putting that disclosure in, it's going to be served up. And so that is that's a tricky question, because then it puts you in a situation of, if you want to get that voluntary disclosure credit, then do you have to start thinking like, do I need to go into DOJ directly even earlier? I think that's Todd's point that he was making a few minutes ago.
Yeah, no, exactly. I mean, if you're going to bring this forward and expose yourself to all the potential risks, right? You may as well do it in a way that's going to give yourself a positive, which is that mitigating fact on disclosure and cooperation and all of that.
And this is obvious, but obviously it needs to understanding each of the the missions and characteristics of those various agencies, from the IG to the SDO to the Department of Justice, and their different roles. And you need to understand the risk profile. And is the U.S. Attorney or the DOJ actually going to be interested in saying, yes, this, it's got to rise to the level of a criminal violation of law, and that if that's the largest risk, then that will dictate either the sequence or the simultaneous nature on who you disclose, because as discussed here, they're talking to each other and they're informing each other of that particular disclosure, so there's no hiding.
And this might actually be a case where, because it's an ongoing conspiracy, allegedly, they may want to actually, they might really appreciate the first one to come in, because they could wire, wire those people and send them in, and they could continue this conspiracy, right, and carry it out.
This is really helpful, because later today I got to send in a disclosure to the IG on behalf of a client that deals with wide-ranging conspiracy overseas, and just hearing this dynamic discussed has been actually really helpful. If it's all right, if there's nothing more to say on this, we'll advance the slides one more to get to phase 3. All right, Todd, you're up.
Okay, so I think we've touched on quite a bit of this, but we haven't really got to the heart of, okay, so you've learned of this fairly troubling fact pattern. You've maybe dug around a little bit, and there's some credibility to it. Now, when you're thinking about what offices to disclose to, David, how do you, can you put some more meat on the bone of the discussion we've been having?
Yeah, absolutely. So how bad is it? Is factoring in my mind. If there are potential criminal violations, which is the topic we were just discussing, that requires one set of considerations, especially the cooperation point we were just covering. If it's going to lead to tens of millions of dollars in a potential felony as a possible resolution, that requires an awful lot more. So I'm not considering just a soft, informal disclosure to the contracting office, right? If I've got a bid coming up, for example, and I'm not sure how bad it is yet, I might consider going to the contracting shop. We see this, here's what we're looking at. We're going to follow up with you. We're going to do the right thing. We just don't know what the facts are yet, because I don't want a client to be in a scenario where they're submitting a new bid, perhaps tainted, perhaps not, I don't know enough yet, without putting the government on notice that they're at least looking into it. And oh, by the way, we're talking with the client about what it takes to affirmatively withdraw the bid if they're going to submit one, depending on what we find later. The soft disclosure, while not getting you credit, certainly with the Justice Department, and non-compliant with the mandatory disclosure rule, can be very helpful, though, to keep the customer informed. This is going to be, for those of you in the government, this is going to drive you nuts, and I'm just going to flag that at the outset. But government knowledge and materiality are quality defenses to False Claims Act cases. The more you put in the government's head, the better it can be for you. So that's a consideration that we're thinking about here. But as with everything else, there are a lot of moving parts, and those are just some of the considerations at the front end.
Yeah, no, I 100% agree with you. There's so many considerations, because when ultimately that is your customer, right? The contracting official and the contracting offices. So ignoring them as part of this would be a bad business move. At the same time, once you share such a serious concern with them, they too have a duty to now report it if they've been trained well. And within the Air Force, they have been.
At least they were. I'm sure they still are. I don't know.
At least they were.
Yeah.
So they would then bring that forward to the IG's office, to the department.
Back in the day, stuff is unbecoming. So.
It just means we're now the old guard. I don't know when that happened. I think it was during COVID. Whatever.
So Mike, when I find myself in this situation, it might just be because of my former days. But what I will say is I'm always thinking, got to figure out this lead agency issue, because that's the one with the biggest weapon initially, right? But and that's kind of informing, where I go with the disclosure and how I think about the preliminary disclosure. And it's almost that initial inquiry is what drives the overall decision making. How do you kind of approach this issue? Do you engage with the SDO's office? Can you walk us through your assessment?
Yeah, I mean, I think if you're making a disclosure and you've got credible evidence of a covered violation, you ought to at least be thinking about how this would look as a reflection of your present responsibility if this information were to come before an SDO. Doesn't necessarily mean that you have to reflexively go to the SDO every time you make a disclosure. Sometimes disclosures are although they technically meet the letter of the law, the standard for disclosure, they're relatively minor, a little time charging issue that's cabined and you've addressed, but I think providing a heads up to the SDO is a good practice. We talked about proactive outreach before. Most SDOs that we deal with like to operate on a no surprises rule, and I think if you can get in front of the issue and give them a heads up, they generally appreciate that. They also, I think, in most cases, will not, sort of throw a monkey wrench in your own investigation either. They will tend to let the investigation play out, just ask that you keep them apprised. And so I think that's a helpful consideration as well.
And so, as we've kind of talked through all the possible stakeholders in this scenario, right? And we've covered SDO offices pretty significantly. We've talked a little bit about the program offices. We haven't really talked a whole lot about the IGs, but at the same time, that is meeting the letter of the mandatory disclosure rule, is sending this to the DoD IG or the agency IG. But David, can you walk us through your thought process, not only criminal, but civil FCA, right? Which is probably the bigger risk in most of these situations. How would you think about whether to bring it forward to DOJ, and how would you go about it?
And I think it always does tie back what is the relationship between who are you talking about with in the government? Is it DOJ civil? Is it criminal? If it's the IG, they're looking at fraud, waste, and abuse, and if there is fraud, waste, or abuse, it's going to go there anyway. If you're talking to the contracting officer, they're probably more worried about programmatic issues, but if it ultimately does rise to the level in this hypothetical, is it potential antitrust violation, criminal violation, or if it's civil false claims, then you've got a different scenario there where it's not necessarily triggered by a FAR Part 3 mandatory disclosure, but it likely is. And if you know that the DOJ is they're out there doing the same thing, just like proactive engagement with the SDO, the DOJ is also saying we'll give you credit if in corporate criminal cases or even in dealing with the civil division to say, if you came in and told, revealed what happened, and you're also, of course, showing that you're mitigating any possibility that this can happen again in the future, then that type of engagement is extremely helpful.
It just occurred to me, David, while you were sharing that, and I can open this up to the panel, if you know that the bids have already been submitted, okay, at this point, and you know that the solicitation and the bids included the certificate of independent pricing, right, which essentially is you're certifying to the government that you've prepared your proposal without discussing it with any of the other offers. It doesn't have to be in there to create an antitrust case, obviously, but that's that much more material. David, what do you think?
That's part of what I meant earlier on by how bad is this, right? So that's an 18 U.S.C. 1001 false statement. That can get criminal real fast. That's one of those things we're talking about with the clients about if we're able to substantiate this, you're withdrawing the bid. Now, we have some leeway here, right? We know contract award isn't prompt after proposal submission, but that time clock is really important, and that's going to be front and center in my mind.
Turn things back over to you.
All right. Does anybody else want to address that? Otherwise, we'll advance the slides.
Well said.
All right.
Move on.
David.
So we want to talk about the typical considerations to have in mind, both in the conduct of the investigation and also in anticipation, which is closely related to engaging with the government and engaging with the SDO as well. As we know that the SDO, all the SDOs are out and they're tasked with saying, we are here it's a business decision on whether or not that particular contractor is presently responsible and that they want to continue doing business with the federal agencies. I think in the conduct of the investigation, not only determining the underlying facts as to whether or not a particular violation occurred, keeping in mind the audience and the government's view of how the results of that investigation will be perceived and how thorough it was is going to be key. And that falls into two main buckets. The first one I'll talk about is really, it's the facts. And the facts will drive a lot of the risk profile of who was involved. In this case, we have the scenario where the CEO was involved, or you have the level of, was it low level, was it high level, and how pervasive was the wrongdoing, and it starts to go towards the lines of cultural issues. Why did it happen? Did you understand what broke down in your compliance system? What was the root cause of this? Did something fail, or did you not have something in place? So going through, I'm not going to go word by word here, but what kind of compliance infrastructure was in place? Let's look and see the contractor's ethics and compliance program. Did it work? Did it not work? Was it circumvented? If it was circumvented, how was it circumvented? And understand not just the facts, again, to say, here's the nature of the antitrust violation, but how did it go wrong? What went wrong? And then if we go to the next slide and start talking about the mitigating factors, these are the regulatory issues that we know that the SDO is charged with going through and analyzing to see whether or not, even though a violation did occur, you're still, this particular contractor is presently responsible, and that you've mitigated any concerns that they have, particularly that this is not, that you understood what happened, you did a root cause analysis, you've implemented any remedial measures, full cooperation again, proactive engagement, have you paid any restitution? They will get down to the granular level as, okay, what kind of discipline was taken against the wrongdoers here? Did you just brush it off and go on? So I think putting both the factual investigative results together with the mitigating factors in advance of any approach to the government is key.
Well said. All right, so we're doing great on time. We'll have time for robust discussion here, Mike,
Yeah,
I think.
Great. Okay, so we're on to phase 5 then. So this is, you've made your disclosure. We sort of talked about this a little bit. Do you reach out to the SDO or not? I think there's more, though, that we can get into here. And so maybe to start, David Hickey, what are the, following the disclosure, what are the principal benefits that you see about reaching out to an SDO? What do you stand to gain? And we'll talk a little bit in a moment about potential drawbacks, but let's start with the positive side first.
And as we just mentioned, the mitigating factor is, did it come through another, so if there is a IG investigation or a criminal investigation, and it comes to your client, that's crisis mode immediately. So you can gain considerable amount by engaging with the government and controlling, first putting the best foot forward, controlling the narrative, and actually relieving the government of the burden of coming in and making really negative assumptions about the client and their program.
Yeah. No, that's exactly right. David Robbins, anything else to add on that? I mean, I think that's the big one. You get to frame it, you get to present the issue, you get to sort of put your story forward and demonstrate that you're being proactive. I think that's the expectation SDOs have of a responsible contractor, but you've been in that seat, David. Is that true?
In a way, it's true. So this is another signal to the government people in the audience. I'm going to drive you crazy again. So part of what we want to do here on our side now is keep the debarment shop informed, but out of the way. We need to investigate. We need time. We need time to tell them what is going on. Our biggest concern is exactly what's come up. Someone brings things forward, whether it's an aggressively investigating agent who somehow gets there faster than we do and frames the issue, or if it's a co-conspirator or even a competitor who wants us out of the way. Getting there first entitles us to an unwritten rule that's not always followed, but there are benefits to it. The SDO will give you space to investigate. They're going to want to see facts. They will have hard questions at the end, but the key benefit in my book is keeping them on the sidelines, and I don't mean that in a derogatory way, but giving us the trade space to do our jobs and help position the company.
Yeah, getting time outside of a 30-day show cause notice is pretty helpful.
Well, because they are people with jobs and bosses too, right? And if they get an inquiry from their boss and say, hey, have you heard about this issue and what are you doing about it? If you haven't been in there first, that this gets back to the no surprises rule, right? Then now suddenly they're on the spot and you're sort of forced to take action in some cases. So, right. So, real positives to reaching out. Todd, that said, we do hear, at least I hear sometimes contractors express, concern or trepidation about reaching out to an SDO. It's a scary, authority for government contractors. That they could put you out of business. And one of the things I hear sometimes is, well, if I reach out, will I put myself on a radar in a way that I might not otherwise be? And I guess two-part question. One, is that a valid concern? Sometimes, all the time, never. And then two, if it is a valid concern in some cases, how do you manage it?
Yeah, I think that's a very common concern. I mean, you're going into an office that you don't know, particularly for small and medium-sized businesses, that they were hoping never to ever encounter, and so I try to walk them through the process and the experience and my positive views of how the system works. And in the rare instances that it doesn't work, there's court for that, and the court system generally works too. So there's a number of due process protections in there, and if you're doing the right thing and you're committed to doing the right thing, that's kind of the way I explain the process. Ultimately, it's their decision, and you can't counsel that there's no risk, right? So you could just counsel on experience. So I think it's a valid concern that I hear regularly. But in a situation like this, I don't even view you as having a choice, because there's third parties involved, and frankly, if this actually occurred, if there were collusion or indicators, if there were discussions about rigging these bids, it's about as egregious as you can go on an ethics and compliance standpoint. And so whoever brings that in is going to have an opportunity to spare themselves, and others are going to be in a whole lot of trouble. So I think just on that risk benefit reward there, it's a no-brainer. You got to bring it in, and that's a bigger risk. Also I think people think, if I don't bring it to the SDO's office, well, maybe I won't be on their radar. I don't view that as either. If the system is working with the investigators, you have investigators at your company. Every employee is a potential investigator, right? A whistleblower. So you have all of these issues working together. The best thing to do is to just be transparent, bring it forward, and know that it's behind you, right? Right.
Yeah. Well, that's good. I think that's good guidance. Your point about litigation is well taken. We haven't really talked about that much. There's not a ton of department litigation. Todd did win a case not too long ago, if anyone wants to look it up. But a great case, and I think a reminder to all of us that that the rules are important and the due process requirements need to be followed, and contractors will have remedies if they're not. Final question, David Robbins. We have very little time here, but if you're managing a parallel investigation with the Department of Justice, now we're reaching out, we're disclosing. How can you manage the flow of information to the SDO while also responding to the DOJ's request for information and providing discovery, giving presentations, all that? How do you sort of keep those two parties informed without getting your wires crossed?
Yeah, it's a very hard question, and I'm going to do this visually. I'm watching good. I've got enough trade space for those who are going to be watching later. So what the SDO needs on a scale from here to here, the SDO needs about that much info. DOJ is going to want that much info, right? Sometimes you have different counsel handling them both, but you can't forget who needs to know what, and you need to be transparent back and forth about the pull and the push. You're never getting a global resolution directed by one or the other, so everybody needs to be kept informed, but it's a constant tension, a constant dance, and people oftentimes think hard about whether having two separate counsel to investigate and to handle suspension debarment. I think that's probably the only time we have to answer that question, but it's a good one.
Right on time.
Excellent. Thank you, PubK. Thank you for the platform. Thank you to the audience.
And with that, we'll turn some time over to the audience for your questions. We have Mike Wagner from Covington and Burling online, and also David Hickey from Valley Drive Warren. And they'd be happy to answer any questions or comments you have about the presentation. We'll give you a minute or two to type that into the Q&A box at the bottom of your screen. Looks like we have a quiet audience this afternoon. If there are no questions, we just had someone pop up. And the question is, any thoughts on entering into an ADR when the contractor has a certified claim pending with the CEO or on appeal at a board? And the government has suggested the contractor needs to conduct a FAR 52.203-13 investigation.
Yeah. Hey, Bill, it's Mike Wagner. I'm not sure if it's okay just to jump in here verbally.
Absolutely. Please do.
Okay, great. Yeah. No, it's a good question. I think what I would say is that, if you're at the point where you've got a claim that's already pending, presumably you've done some investigation already, and you should have a pretty good understanding of the facts that are at issue, and including whether or not any of those facts might give rise to a disclosure obligation under FAR 52.203.13. And so if you're at the point where you're litigating a claim and even thinking about entering into ADR, and someone suggests from the government side that there's a need to disclose under 52.203.13, if you haven't done so yet, hopefully you've got a pretty good reason where you can respond and say, this is why we don't have credible evidence of a covered violation in connection with the award, performance, or closeout of a government contract, which of course is a standard for a disclosure under the FAR. If you do have to make a disclosure, of course you can do so. If you're at the board, which I think is what the question here contemplates, the board does not have jurisdiction to hear anything like a fraud counterclaim. That jurisdiction, the board's jurisdiction, specifically excludes fraud-based claims, and so you wouldn't be at risk of a fraud-based counterclaim, even if you were to come in and make a disclosure to the SDO, or excuse me, to the IG. But it's still certainly something that could color the dynamics of any negotiations, whether in ADR or more informally. And so it's something that you just want to make sure that you're coordinating and providing a consistent and sort of comprehensive story when you're making your disclosure, especially given the possibility of discovery and litigation. You don't want to be, subject to further questions down the road about information that's discovered in the course of, litigation, and why you didn't present that with your disclosure. So if you do have to disclose, you just want to make sure you coordinate. You wouldn't be subject to a counterclaim for fraud at the board, but certainly something that would still need to be coordinated, and consistency would be important.
I can piggyback a little bit off of supporting Mike's answer there, Bill. I think if you are entering into ADR and prior to receiving the suggestion from the government, you just viewed it as a dispute related solely to a contract claim, clearly an allegation of that sort that implicates that there's been some violation of criminal law or Civil False Claims Act, that clearly changes the tenor of that, either the tenor of that negotiation posture or the tenor of the entire claim itself, on what the basis for that suggestion that there's been a serious violation associated with that claim is. So to Mike's point, you can look down from that point as you enter into ADR and look at the possible scenarios that might flow should the suggestion from the government turn into something more, something much higher risk and much more likely to occur, that bringing this claim all the way through the process and understanding that the civil division, that if it does go to the Court of Federal Claims, could counterclaim for fraud. You need to drill down into that investigation and make sure that what the basis of that suggestion is, and whether or not it's simply a suggestion that is based on a negotiation posture, or are there real facts that you need to understand before proceeding further, because it just became a higher risk alternative dispute resolution process.
Okay, well, thank you, Mike and David, for joining us today for the Q&A session. Looks like we don't have any more questions popping up, so we can close just a couple minutes early and give everyone a few minutes back in their day. Thank you all for joining us for this broadcast of the Investigations and Suspension and Debarment panel from our live conference in February. We hope you enjoyed the presentation. Mike and David, thank you again for joining us for the Q&A, and thank you and Dave Robbins and Todd Canny for all your efforts for the in-person presentation. We do appreciate it. We couldn't do it without you. So thank you. Our next session will be this afternoon. It's a conversation with Department of Defense Inspector General Robert Storch, and that'll start a little bit later this afternoon. Thank you, everyone.
Thanks all.
Thank you for joining us today. And thank you to our panelists for their presentations and live Q&A. And again, special thanks to our sponsors whose support made this event possible.